Last term, as you all know, of course, the Supreme Court decided Walmart versus Dukes, which is a Title VII class action case. And since then, creative defense types have tried to bleed Dukes into Fair Labor Standards Act collective action analysis. And Ed Sullivan, board-certified super lawyer and FLSA expert, is here to tell us about how that's been going.
Okay, well, the answer is not very well for defense lawyers. In 2011, the Supreme Court, in a case of Dukes versus Walmart, determined that the plaintiffs in that case couldn't sustain a class action lawsuit against Walmart because there was a lack of commonality under the federal class action rule, actually Rule 23A2. What the defense bar has tried to do in large measure is to take that decision and argue that in Fair Labor Standards Act cases, which are different than the Title VII case that Dukes was under, a sex discrimination case Dukes was under, but that in Fair Labor Standards Act cases, in order to get a collective action, plaintiffs have to meet a low bar, a similarly situated standard test. And they're trying to say that the Dukes court, in saying that plaintiffs against Walmart didn't meet the commonality test, that logic should apply to overtime cases and should also prevent courts from certifying cases under the similarly situated standard. It gets a little complex, but the large measure of it is it's not working. The vast majority of the courts that have looked at the issue have determined that the similarly situated rule under 29 U.S.C. 216B of the Fair Labor Standards Act is different than the class action rule under Federal Rule of Civil Procedure 23 for commonality, and therefore Dukes is having very little applicability at all to Fair Labor Standards Act cases, although there are a couple of outlier courts on that very question.